Hi, I'm certified elder law attorney Tammy Weber. We're often asked, do I need a power of attorney and an executor? Well, the answer is yes. Let's talk about both roles. A power of attorney is a legal document that applies during your lifetime, and you name an agent, the person to make decisions for you. Here at Marshall Parker and Weber, we divide the power of attorney into two categories. One that applies to financial items and one that applies to healthcare items. If you do not have a financial power of attorney document and name an agent, there's no law in Pennsylvania that allows somebody else to act for you. What would happen is your loved ones would have to petition in the county in which you reside to become your guardian. A physician needs to be involved. This takes some time and it costs some money. And it may not be the person that you would choose to be your agent under the financial power of attorney. In terms of healthcare, if you don't have a document, there is an act in Pennsylvania, Act 169, that's been around since 2007, but there is a pecking order, if you will, of who would be your decision maker if you were not competent to make your decisions and didn't have a document. That order may not be what you want. For example, if you're married and you have adult children of a prior relationship, that current spouse and your adult children stand in the same shoes, meaning they're all the first on the list to be your agent. And your adult children could really outvote your current spouse. Is that what you want? There are also some limitations under Act 169 regarding end-of-life decision making. That may not be what you want as well. So let's do a healthcare power of attorney where you name an agent. Each document can be used during your lifetime. The financial power of attorney can be either immediately effective, meaning when you sign it and give it to your agent can use it, or what's called springing, meaning when you sign it, it can be used only with a physician note attached to it saying that you're unable to handle your financial duties. A healthcare power of attorney, though, is springing by definition, meaning if you sign it, you give your child the ability to be your agent. They can't use it unless the physician has seen you and knows that you are no longer able to make or communicate your wishes. Powers of attorney, as I said, are lifetime documents, and when you pass away, they end. That's why you need an executor, sometimes known as an executrix, depending on the sex of the person that you've chosen. That's under your last will and testament. Pennsylvania does have a law that if you die without a will and you haven't named somebody, or the people named in your will no longer are alive or don't want to serve as your executor, they list a pecking order. Again, it may not be the person that you want. So think about it when you're doing or updating or doing your will for the first time, who you want to be your executor. Their jobs are to follow your will, to get your assets valued, to make sure that the Pennsylvania inheritance tax is paid promptly, and to distribute your estate to your beneficiaries. Both are very important jobs, an agent under a power of attorney and an executor under your last will and testament that you need to think about. Plan ahead, do those documents, because you don't want the state or your family or a court deciding who can make decisions for you if you can't. For more information, go to paelderlaw.com.